No, the problem was not you going to vote. And I will tell you, I teach campaign and election law. No,
Well, they
that's the
would have
law.
told me that.
I'm telling you, that's the
Well, I'm
law.
telling you, I didn't know and other people didn't know. I'm explaining my situation. That doesn't seem that.
And why all this hesitation and this, I don't know, attitude about, yeah, I think she's okay or whatever you're saying. I'm sorry.
No.
All right. So when you're drug tested today, because I see you don't want to do a drug test.
I'm not gonna do a drug test.
Yes, you are.
I'm not.
Okay. Can you put her in the box?
Yes.
Then maybe you want a jury trial and you want to say it's self-defense.
It's on video. The only reason why I'm accepting that, because I don't have the money to continue. Or of course I would defend myself.
Speak to you stating that he was unable to do his sober support meetings.
Not that I can recall, Your Honor, no.
All right. Any questions?
Nothing from the state.
Any? It's nice to see that people still claim their teams, whether they're winning or not. Take note, people, take note.
Yes.
All right, so where are we on this case with regards to discovery?
Yep. Well, discovery, I believe most discovery has been given over, Judge.
Okay.
Granted, we cannot offer a plea at this time because we haven't contacted, well, we're in process of contacting the victim.
Okay. All right, Ms. Ferguson. Set this in 30 days, please. June 26th, is that good for everybody?
That works for me, Judge.
All right, good for
Hey,
you.
You too, and that's a day after the Spurs won the title. They won their first title on June 25th, 1999.
See, this is what I'm talking about. People who always love their teams, win,
Yeah.
lose, or draw.
That's my other team.
Oh, yeah. Well, I will say, even though I'm from Louisiana, because I'm in the northern, we were in the northernmost part, we would never get any Saints games. We would only get Cowboys games. And it was back in the day with Roger Staubach. So you would watch it. And I'm telling you, if there were a minute left in the game and the Cowboys were down by 30 points, you still felt like we can still pull this out because they would pull it out a lot.
That's true.
But then once Tom Landry left, we were all like, you all didn't let him leave the correct way.
Exactly. Well,
And then I got upset with Baum
They called him
Phillips.
into the office and told him he's going another direction. What, how else could they have done it?
Okay, now look at Scott Simpson. He don't understand.
That's an attorney, right? That's an attorney answer.
They should have given him a celebration and said, hey, look, I'm going to bring in somebody. You just don't get rid of somebody like that who's given you years. What if they would have told Jimmy Ellison bye instead of giving him his celebration? But I still have issues with Houston. You remember when they were the Houston Oilers?
Right.
Because Baum Phillips brought all of those people to the Saints. How can I say this politely? Past their prime. We're up there dealing with Earl Campbell, and I know that y'all, yeah, but bringing the Stabler as the quarterback and Stabler, but okay. All right, enough about football, you know. LSU is going to do it this year.
I don't know about that.
So is Florida.
I don't know
what
that
the
either.
Cowboys going to do. They're going to win a couple of games.
Got some good people coming in.
All right. You know what, Faith? You have the faith. I appreciate that. All right. So we're going to be back on June 26th. And at that time, an offer will be due.
Yes, Your Honor.
And be sure to tell your owner that either he's going to be the owner or if he's going to coach. When you bring somebody in to coach, you got to let them coach.
Yes.
You know, when they say, put me in, coach, they can't be calling the owner. It's supposed to be the coach on the sideline. Yeah. But good luck. Yes, June 26th.
Thank you, Judge.
All right, thank you. Good seeing you.
You,
I
Judge.
love that color blue.
Thank you, Your Honor.
All right, have a good
I
one.
like all your flowers all the time.
Oh, thank you. You know, they should bring happiness.
Thanks, man.
You've been waiting patiently. Hello, Jonathan. You're always looking dapper.
Judge, I knew I was coming here, so I had to play the part.
You never stick to the basic, which I like. Neither do you. And I like that.
Thank you, Judge.
All right. So today an offer was due. Has an offer been tendered?
If the state may speak on this, we
Yes.
believe Mr. Garahan was going to extend an offer. We're asking for a short recall so that Mr. Garahan can get back, make that offer. In conferring with defense, we weren't sure if this was actually the third setting. We are thinking it's the second.
Yes.
Even though the docket says 3.
Yes.
But we are hoping for a short recall for that offer to be made before it's put on the trial docket.
All right. Ms. Ferguson,
Yes, ma'am.
can you recall this for the third week in July? Is that good for everyone?
Yes, ma'am.
All right, if you'll make sure Christine Brown gets copies of that, please. All right, so today an offer was due. Were you all able to attend an offer?
Judge, we're in negotiations. I've conferred with Mr. Garahan. And Your Honor, I just would like a 1 month reset. We want to talk to our client, like, there's a chance we could work it out, and I'd like to just talk to him and go through that with my co-counsel.
All right, Ms. Ferguson. On this case, if you can give me a 30-day reset for a plea deadline date, please.
So Judge, even like if you had anything in early September, I don't know if you do.
Sure, I understand what's going on, counsel.
Thank
Okay,
you.
Ms. Ferguson, if you'll put this early September.
Yes.
That's perfect.
All right, and everything's gonna go well for you. I know it.
Judge, I'm doing my best to do my duty,
Oh, no, you know what?
and thank you for
The-
sharing.
Sure. You know, the key, they tell me you remove the stress, right? So it's gonna be fine.
Thank you. I really appreciate that. I always like the flowers too. It's good.
Hey, you know what? We gotta bring some beauty somewhere.
Amen to that.
All right. Thank you for dressing appropriately for court. Just have a seat. Once you sign the reset form, you're excused.
Okay, thank you.
Mr. Lutzenberger, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yep,
That's either yes or no.
yes,
All right. Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
that's here.
No. Did you review this document? Did you understand it?
Yeah.
Did you sign it in all the appropriate places?
Yes, ma'am.
The state is proceeding on the lesser included offense of assault bodily injury as a class A misdemeanor. The range of punishment is anywhere from a $4,000 fine and up to 1 year in the Bear County Jail. Did you understand?
Yes.
If you have a,
Just that we wish that you follow the agreement, Your Honor.
all right, what were your issues that day?
Were my issues with this?
Yes.
Well, I couldn't believe it was happening because all I wanted to do was go vote.
No, the problem was not you going to vote. And I will tell you, I teach campaign and election law. And when people at a location tell you that you're not allowed to wear certain items when you go into the voting booth, you're not allowed to do that. When they tell you you're not allowed to wear certain items when you're entering doors, you're not allowed to do that.
They told me it wasn't posted anywhere, and the people that were working there didn't know themselves.
No,
Or they
that's the
would have
law.
told me that.
I'm telling you, that's the
Well, I'll
law.
tell you, I didn't know, and other people didn't know.
Well-
I'm explaining my situation. That doesn't seem that anybody's heard yet.
Oh, well, let me just tell you what it says in here in the police report, because maybe you didn't read it. It says you were walking in and the person, they have judges who are there for voting and they have people who are working there,
Mhm.
who work there. It's yes or no. It's not, uh-huh.
Okay.
They were working there and they told you you needed to remove your hat because it was not allowed inside the voting area. And that's the law. And that's always, but here's the thing. That's the law. It's always been the law. For example, I can't walk around with a T-shirt with my name on it saying, vote for me and go in the voting booth. It's not allowed. Once you get to a certain point, and it's that 100-yard line that they have, when you cross into that area, you're not allowed to be in line with T-shirts about who you support. You're not allowed to do that. That's the law.
I
And
understand
then when people tell you that, you can't start hitting somebody. And it says on here that your wife even tried to stop you.
Ma'am, that's all incorrect. Do you want me to explain? Can I explain?
Sure. And if you want a jury trial, I'll give you one.
No, I'm not talking to you, I just want to explain because it's incorrect what they're saying. I was in line for 45 minutes before I actually got to vote. They asked me to remove my hat then, after I was standing there for 45 minutes. So I removed it, I put it in my lower back. I went through the whole voting situation. When I went out the other side, this person that had already harassed me in 2 other previous times that I went to go vote in a different location
Mhm.
was again there. I walked away from him twice, 2 other times, when he was verbally harassing me.
Mhm.
Okay, this is the 3rd time. And this 3rd time, I walked away from him again twice. He would not let me walk out of that place without harassing me and getting physical with me.
All right, so
That's what my wife was trying to.
let me tell you what it says in here. And I go by this document.
Mhm.
It says that the complainant went on by explaining that as part of his duties, he is supposed to advise voters that they are not permitted to wear or display candidates on their person while they are on the polling premises. It says he observed an older adult male inside the polling premises, and you had displayed campaign material, which was your hat. He observed the violation. He contacted the male and advised him that he would need to refrain from wearing the hat while on the premises. The complainant explained that the male complied with his instructions while he was voting, but then put the hat back on as he was making his way to exit the premises. At the time, the male was still inside the building and clearly well within the premises. Due to still being well within the premises, he approached you again and advised you to remove the hat while he was on the premises. The male, that's you, explained that he was on his way out and refused to comply. And it says, he began to follow you and told you again to remove your hat. And as you were about to exit, you struck him on the chest and facial area several times with your fist, causing him pain and discomfort. And then it says, another witness and your wife began telling you to stop. And then that's when you left. I don't know why when people go to places, how hard it is to follow instructions. When they say you can't do something, you can't do it. And if you want to complain about it, complain to your legislature. If you want to wear campaign materials inside a location while you're voting, if you want to wear it within the 100 lines, because they have those lines marked with a white, sometimes yellow line. If you want to do that, then you need to write your legislator and say, look, you need to change these rules because I want to wear my campaign gear inside the area while I'm voting. But for now, you're not allowed to do that. And you need to follow the rules. How old are you?
Or
All right, you're 64 and you're up here fighting at and I don't even call it fighting because it doesn't say that he ever even hit you back.
yeah, of course.
And so you're up here fighting with somebody who's just trying to do their job, help people come in and vote and go on your merry way. And they're not even paid enough money for somebody to be hitting on them. So it appears to me you do have anger issues.
No, I don't have any. Like I said, I walked away twice, and in the situation, I walked away twice. To say anything in there where he followed me all the way and he screamed in my ear. I have hearing difficulties from my time in the military. I didn't hear what he was saying. I was walking out, and he was quite a ways.
Did he not
from
tell
me.
you to remove your campaign gear
No,
and that you were not allowed
That was-
in the area?
that was after the fact when I had already gone out. I was in the library section already.
Let me just tell you, within that 100 line, you are not allowed to wear campaign gear. Now, if you're saying what's being said is untrue, then you need to set this for a jury trial because I go specifically by what's in the police reports. And there's a reason why this says waiver consent to stipulation of testimony and stipulations. You know what that means? That means that everything is in this document. You're stipulating that it is true and correct. And this is what it says. I, Jesse Lutzenberger, do hereby judicially confess and admit that I intentionally and knowingly in Bexar County, Texas, on or about the 24th of October, 2024, did intentionally and knowing cause injury to the complainant by striking the complainant with the hand of the defendant and by pushing the complainant with the hand of the defendant. That's, you stipulated to that and said it's true.
Say anything about him punching at me first.
What I'm telling you is you're saying this is true.
I get
You've
it.
stipulated to this. Now, if you're saying he punched you first, then maybe you want a jury trial and you want to say it's self-defense.
It's on video. The only reason why I'm accepting that, because I don't have the money to continue. Or of course I would defend myself.
All right, does he
That's
want a
fine,
jury
we'll keep
trial?
going. No, we're accepting the plea or, you know,
Is your wife, is somebody here?
my wife is here.
Oh, she said, no, you don't want a jury trial.
Okay, no.
All right.
Your Honor, if I may, I believe that, look, point being, there's, as you've stated, that's completely clear. The law is the law. I think that there was a fundamental miscommunication and understanding as far as how it was proffered to him at that time. I think that realistically, the way people speak, someone told him, take off the hat while you're voting. I think in his head, that's what he believed. Hey, take the hat off. I'm walking out the door. I'm basically at the double doors. I can put the hat back on. Understanding clearly that is still in violation of the law. But I want to make clear, it's not like the statute book was not pulled out and read to him at this time to understand the 100 feet. Again, it's not an excuse, but I think where his mind was coming at, he had finished voting, he had waited the 45 minutes and he was leaving. And then he had an individual come up and approach him. Just to give some context, it's not change, obviously, the law itself or your viewpoint of this, but I want to.
Well, I mean, my viewpoint is the stipulations that I received.
Understood.
All right. There's going to be a $500 fine. 2 years deferred adjudication. 200 hours of community service restitution. Is there anything else you need from the court to be successful?
No, I'd just like to say that all this is my self-defense. Because nobody wants to be harassed or bullied in front of their significant other.
Yeah. I understand, you know what? I understand here's the thing. I understand what you're saying. And I understand sometimes that tempers run high, right? And sometimes when we don't know the law, and if somebody just tells you, you can't do that, sometimes people want to know why I can't do that. And they want you to explain it. Sometimes people will explain it, sometimes they will not. For example, I try to explain everything so people will know why things are happening. So now you know, and I'm telling you, yeah. So here's the thing, this is what I'm telling you. When you see, if you go vote again, when you see that line, you are not to cross that line with any campaign materials. And that's why when you see candidates who are out there talking to people, they're not allowed to go past that line. You know why? Because you are not allowed to campaign past that line. And wearing T-shirts or any type of hats or anything for whatever candidate you support, whether you say anything or not, that's considered campaigning. And legally, you're not allowed to do that. And if people want to change the law where they can wear their campaign shirts or whatever beyond that line, you have to do that with your legislators. My job is just to follow the law. You understand?
Mhm. Yes, ma'am. This happened in Georgia and it happened in South Carolina, I think, and the people still got to go and went on their way.
Well, this
Different place, right?
is Texas.
Yeah.
All right. Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and sign it?
Yeah.
All right, because this is plea bargain agreement, because I've followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right. Ms. Abrams will speak to you.
Okay.
All right. Thank you.
Thank you, Your Honor.
You're welcome. So, Miss Ibarra, you are on probation out of this court for criminal mischief. And it's a state jail felony. So if you were revoked, how much time are you looking at, do you think? What do you think the range of punishment is for that offense?
Not sure.
Up to 2 years in the state jail facility. And going to the state jail facility is different than going to prison. Because at the state jail facility, it's day for day time. So if you're sentenced to 2 years, you are doing 2 calendar years. And the report I'm receiving on you is you don't want to do your UA and you're not reporting. So that tells me that maybe you want to go to prison. Would you like to go to the state jail facility? I can't hear you. I'm sorry.
No.
All right. So when you're drug tested today, because I see you don't want to do a drug test.
I'm not gonna do a drug test.
Yes, you are.
I'm not.
Okay. Can you put her in the box? Yes.
I was gonna say, we tried this and we went to the ladies' room and she refused to submit.
All right. If you'll file a motion to revoke, please,
Yes, Your
and we will sign that.
Honor.
Let's go.
Mr. Carmona, are you employed?
I am, Mr. Honor.
What do you do?
I'm a call center manager.
What does that mean? For which company?
So I work for Go Health. What we
Okay.
do is Medicare licensed agencies to enroll 65 and older.
All right, why do you keep showing up at Ms. Hernandez's place? She doesn't want you anymore.
A lot of things were just to assist with the children.
She doesn't want you anymore. Do you understand what protective orders mean?
Yes, ma'am.
That means that you can't have any contact. That means that when I read in the police report that you're at the apartment, she's not there, which means if she's not there, that means that there are no children there. How old are the children?
He's 4 years old.
He's 4. So when you went to her apartment and she wasn't there, there was no 4-year-old there. So don't come before me telling me that you're doing this because there are a lot of child things going along. You still want her. She doesn't want you. She doesn't want to be bothered by you. The only time you can see her is when you all are in civil court with the divorce. Do you understand?
I do. Yes, ma'am.
How old are you?
42.
You're 42 years old. How long were you married?
Almost 7 years.
7 years?
So
So that means that you've been alive on the planet longer than you've been married to her. Let it go. You're not a teenager. She doesn't want you. If you violate the conditions that I'm going to give you, what's going to end up happening is you're potentially going to prison for 10 years. Do you understand?
yes, ma'am.
Is there anything that you do not understand that I'm saying to you?
Oh, no.
If you are at the HEB and you see her at the HEB on aisle 2 or whatever, you need to leave that HEB. If you see her walking down the street and you're walking on that same street, doesn't matter if you got there first, you need to leave that street. Do you understand?
Yes, ma'am.
She does not want to be in a relationship with you. If you all are working out arrangements through your divorce where there's child arrangements, that needs to be done through a third party. Do you understand?
Yes, ma'am.
And if she gets involved in another relationship with somebody else, not your business. Do you understand? Well, you say yes, but you're here for repeated violation of bond conditions and protective orders. She doesn't want you. You got to accept it and move it on. You understand?
Yes,
And
ma'am.
if on the inside you are breaking down and your heart is broken and you think it's broken in a million pieces and it will never recover, pretend like your heart is not broken and keep moving. You understand?
Yes, ma'am.
All right, this is what the court is going to do. There's a $0 fine, 6 years deferred adjudication. Take in consideration CM 112993. There's to be no contact with Linda, Stephanie, Martinez Hernandez. And when I say you have contact during court hearings, that's through your attorneys. So there's no out in the hallway, hey, let's be nice to each other. Let's work. No, you're not to have any conversations with her. You understand?
Yes, ma'am.
Unless it's court ordered. So there's to be no contact with Linda Stephanie Cortines Hernandez without a court order. Mr. Carmona, because of your history with this violation of protective order, I am going to give you GPS. I'll do tracking only. I'll waive the fees. Counsel, once he shows that he's able to obey court orders, come back in about 4 months. We'll see how he's doing. So GPS tracking, waive or defer fees. Are you going to be living with your parents? Where are you going to be staying?
My house.
You have your own place?
I have my own house.
All right, I'm gonna want field visits 1 time per month until further notice. From here on out, everything that you do, you need to ask yourself 2 questions. One is what I'm doing, could it potentially result in me going to prison for 10 years? If the answer is yes, don't do it. If the answer is maybe, don't do it. Do you understand? And I am serious about you not having any contact with her. I don't know. This is the last time I'm going to say it. She doesn't want you. She doesn't want to be in a relationship. She doesn't want a Valentine's Day card from you. She does not want a Happy Mother's Day card from you. Do not send that. And if you do any of those things, if you email her, if you text her, if you send a card, if you send flowers just because, if you send something saying, I apologize for the way I behaved and this divorce is my fault, that will be a violation. Do you understand?
I do know.
And do not have third parties contacting her unless it's your parents or somebody approved by probation to make arrangements for child visitation. Do you understand?
I do know.
All right, good luck to you.
Thanks.
And,
Thank
and
you.
I was gonna ask that judge, if we could have the parents make connections with the mom for
For
visitation.
yes, for visitation, yes. You all ready to proceed or are you requesting?
Your Honor, we're gonna request a reset because, the state has not received the blood results. However, he's in the box because there's a warrant that came out on an MTR, but I had already posted the bond. And
Okay.
I've got it right here in front of me. And I posted the bond on May 31st, but the warrant was issued, how that happened, who knows? June 26th of 2024, so there's gotta be a problem with Odyssey or something. But
Okay,
If I may. It's the same case number. That's the one that he's remanded without right now.
Should be judged that maybe a violation order came out later.
okay. All right. Is there any objection? Is there going to be any objection to the court since he has made the bond to recalling the warrant on that case? All right. So we're going to go on the record with regards to the bond matter, and then we'll speak about the continuance.
Thank you.
So you are in custody because there was a warrant issued in this cause number. Counsel has tendered to the court, I'm assuming state without objection, proof that the defendant has posted a bond.
We've seen it, Your Honor. No objection.
All right, so the court has reviewed that. Without objection, the court is going to recall the warrant in that case because he is technically on bond with defense. I believe there may be an issue with Odyssey as it relates to that. So we'll recall the warrant.
Thank you, Your Honor.
You're welcome. And family violence.
Well,
This,
Judge, sorry.
oh, no, sorry. This case, I believe the motion to revoke is under your purview as far as the charge, because it's a repeated violation of court order or bond condition. If you can make sure the complainant knows that he has made bond, so he's not going to be in custody.
Yes, Judge.
All right.
And just so the court will know, Your Honor, we're here for an MTR based on that, on the allegation of the DWI. And I don't want to ask for a reset on the DWI and then not tell the court that we're here for this case also.
Oh, no, no problem. I just wanted to make sure, because I know that the state is handling the motion to revoke because of the allegation.
Yes, ma'am.
But I wanted the complainant to be aware that he's on bond.
Yes, ma'am.
All right, so now let's address the issue with blood draws or discovery. Is that date?
Judge,
Agreeable?
I'm gonna be here on the 26th on your court on Mr. Aceves.
All right,
So we-
26.
If that's okay with you, please.
All right, so we'll recall for August 26th, and we'll come back on August 26th. And you need to bring me proof that you've done those meetings. Do you understand?
Yes, ma'am.
All right, is there anything else?
Yes, Your Honor, and I heard what you explained in the case prior to us.
Mhm.
But I'm asking the court if we can put him on tracking on GPS. He's been on tracking on the MTR case since about October the 23rd, on partial, I'm sorry.
Mhm.
And we're asking that we be on tracking only, so.
Well, if I may.
You want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, I do.
You can lower your hand, state your name for the record.
Stephen Carmona.
All right, what did you want to say?
Originally I was put on GPS for the offense for violating the no contact order.
Mhm.
And that was in the beginning of October, I believe it was 5th or 6th that I got put on GPS tracking only.
Mhm.
I have had no contact with the person since then, so now for 9 months. The issue that I'm having is that I have one in employment, my corporate career, that I gotta go, I'm on call, I'm a call center director. And I understand I've already submitted to my officer, my
All right, so
work
this is what I can tell you. If you want to be on tracking only, I will need the state to be able to contact the complainant to see if the complainant has any issues with that. And when I ask if the complainant has any issues with that, I just really want the complainant to be aware. Of course, I ultimately make the decision whether it's tracking or partial. So your counsel will need to confer with the state, and then you all can come back, and you can come back on any date for me to address that issue.
Okay, sounds good. Thank you, Your Honor.
All
Would
right,
he have to come back or just me?
he can appear by Zoom.
Okay, thank you, Your Honor.
All right, thank you.
Yes, ma'am.
That'll help with my 5-year-old.
All right, and on that one, the warrants recall.
Mhm.
Stephen?
No, it's Stephen Samuel.
Okay, I don't, on the motion to revoke and all the paperwork, it says Stephen.
I think that's because the way the DPS issued my license, they put Stephen.
Ah, so your license is Stephen.
Yeah.
Ah, okay,
I've called and tried to get a new one, but. they
all
told me-
right. Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney?
Yes,
Did you understand it?
I did.
Are you the same Stephen Carmona who was placed on deferred adjudication in 2023 CR 8639W for the offense of repeated violation court order bond condition on October 3rd, 2023 for a period of 6 years? Is that you?
Yes, Your Honor.
All right. Offense?
Judge, I'm recommending that you continue him on probation. He's been doing good. He's been on the GPS for 11 months approximately. And he hasn't had any violations. It's in the actual report that there's no violations. There haven't been any violations. And other than drinking alcohol that day, he's been doing wonderful. He's doing good. He's been following my advice. He's been following the court's advice or orders. And he's doing great, except for that one mistake, bad decision, not a mistake, bad decision. And I'd like for him to just continue him on probation, and let's keep seeing how he continues. And if he continues to do well, then he'll be successful.
All right, so last time we were here in July, the warrant was recalled. And I asked that he complete daily sober meetings. Has that been done?
No, Your Honor. I recently have.
Let me have you raise your right hand for me.
Oh.
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Stephen Carmona.
All right, so I ordered daily sober meetings. Why hasn't that been done?
I recently got an employment as a director of operations in a call center. Gives me 7 to 7 hours, Monday to Friday. I also have a 5-year-old that I share like joint custody with. So I have him anytime his mom is at work. She works in the evenings. So she goes in anytime between 7 p.m. and 9 p.m. So because of that, I couldn't find any virtual AA meeting. And the only ones that I could attend would start at 10 o'clock.
All right, so did you come into the court and tell me or tell your probation officer, hey, I know the judge ordered daily sober support meetings, but here's the issue I'm having?
I did tell my probation officer this past time that I saw Ms. Guerra, and she did tell me that I could go online for resources, and she provided me a link and information so I could go and start attending it. This was this past week.
All right, so I had ordered that since July 11th.
Yes,
Why are
ma'am.
you only doing it this past week?
So initially, when I did talk to my probation officer, Ms. Guerra, she had told me not to report because of the fact that the systems were still showing an active warrant. So the last time I was in here, I was detained. I thought it was for failure to appear here, but it was, she told me that it was failure to report, which I wasn't aware of. And when she did call me and tell me, that's when I went and reported, and that's when I gave her all the information.
All right, any other questions?
Other question.
Ms. Abrams? So has he spoken to his probation officer about the sober support meetings?
I was just reviewing, the notes on the case.
Your Honor, if I may,
Yes.
I would like for you to continue him. And I will promise you, I will have a very stern conversation with him about following the court's orders. I know it's July and then August, so we're missing a few days here that he didn't do what he was ordered to do. But I will have a very stern conversation with him. I will tell him, as he already knows, the possible results of what can happen if he doesn't follow the court's orders. But I've gotten to know Mr. Carmona since he retained me, he is a fine young man. He has been doing well with the orders other than the alcohol consumption and this. So if I may get a little bit of an extension for him so he can start doing what he needs to do. And then we're due back in January. So on the other case, and we can come on that day or we can come anytime in between there,
All
Your
right.
Honor.
So let me ask you this, is it possible to have his probation officer zoom in? All right, so we have Officer Norma Guerra here. Any objection to the officer appearing by Zoom, state
No.
defense?
No, ma'am.
Do you have any objections to her appearing by Zoom?
No, ma'am.
All right. Ms. Guerra, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand, state your name for the record.
Officer Norma Maya Guerra.
All right, any objections to the court just getting to the crux of the issue?
No, ma'am.
All right, so officer, the court ordered Mr. Carmona to do sober support meetings daily until, beginning July 11th until today. Mr. Carmona has testified that he spoke to you about his inability to do the meetings. Is that correct?
Sober meetings were never discussed with him.
We discussed it on the exit when I was leaving.
On the exit when you were leaving, I
Yes,
don't
ma'am.
recall talking about sober meetings, sir.
All right, so Officer Guerra, did you ever speak to him about sober support meetings?
No, ma'am.
Did he ever speak to you stating that he was unable to do his sober support meetings?
Not that I can recall, Your Honor, no.
All right, any questions?
Nothing from the state.
Any questions?
No questions, Your Honor. Just re-urge my argument.
All right, thank you so much, Officer Guerra.
You're welcome. Is that it, Your Honor?
Yes,
Okay.
thank you. All right, so the officer has testified that no one spoke to her about sober support meetings and the inability to do those.
We spoke, Your Honor. It was on the exit because I had told her that I was ordered to do 7 days daily. And she was surprised because I felt like it was a lot for me to do, given my situation, my income, everything that I have to pay for. She's the one that told me, I told her that I've researched 12 and 12, I need to be a member to do the virtual meeting at 7 o'clock in the morning. She also was the one that said, well, I've had another person that I've been working with, and I advised him to Google virtual alcohol meetings. It was on the exit as I was leaving probation. I wouldn't come up here and put myself at the mercy of the court, trying to claim some ownership for what I've done. I understand that it's wrong, right? I do. I fully take responsibility for that. My thing is that, you know, like I was telling Mr. Cisneros, is on paper, it might look like I make money, but I got a mortgage, I got child support, I got utilities, I got other fees like GPS and probation and bondsmen. And so when it's all said and done with, I'm limited. You know, I got my 5-year-old that I take care of half the time, so his mom can go to work in the evenings. I mean, there's a lot of things that I'm doing, you know, and that's where I ask for you, please, to reinstate my probation. And, you know, it's one of those things where I've gone through a whole bunch of stuff. My divorce after 18 months was finalized in July. It's just a whole bunch of stuff that's been going on. And
All right, any questions, state? All right, so Ms. Abrams, in state, in the defense. So in this case, the person I have before me, this is his first motion to revoke, and it's for drinking alcohol, which he's not allowed to drink alcohol. I know I ordered sober support meetings, and that wasn't done. And I do know that I tell everybody, if there's an issue, you can come back to court and address it with me. And I guess when I order people to do things, they're like, you know what, let me just come before the judge and say, I wasn't able to do it. Instead of coming in, nope, don't give me attitude. All right. Instead of coming in and saying, I have an issue with sober support meetings. This is what's going on in my life. Then that could have been something that perhaps we could have figured out. But when people are doing their own things and then come to me at the end of the day trying to figure something out. Something should have been figured out in July.
I agree.
Your Honor,
I don't mean no disrespect at all, you know, and it was maybe something that I just didn't know. I mean, I have called up here to the courts and I talked to, you know,
No, I tell people to come in.
yeah.
Do I not tell people that they can come into court?
I
Just one
understand.
second, Miss Abrams, there's something you wanted to say?
Oh, no, Judge.
Okay. All right, so
Judge,
then,
if I may say one more thing.
yes,
And excuse me for interrupting. The probation officer opened the door about there being a possibility that he did talk to her about it, because she said, not that I can recall. So I'm believing my client that he did talk to her about it. And of course, there's still the he said, she said situation, but she herself, and I'm gonna repeat myself, but she said that not that I can recall. So I think, again, if I may re-urge my request of the court to just give him another chance, I'll have a very strong and stern meeting with him and conversation and tell him that it's, while we understand it's a zero tolerance policy now, I will make sure and reassure that he knows what zero policy means and we can put him on or zero tolerance. So I'm asking for one more chance for him. I've gotten to know him, like I mentioned. He's a wonderful young man, just didn't follow the court's orders. And I don't think he understood the gravity of the situation. And we're just asking for a continuance, Your Honor.
anything else from the state?
No,
All right, what he has done as a violation of his probation, he was placed on probation October 3rd, 2023. And this is his first violation, and it's drinking alcohol.
that's correct.
All right. You are not allowed to drink alcohol while you're on probation, period. Doesn't matter if you're in your house, doesn't matter that alcohol is legal. Those are the rules that the legislature set up. It is not my rule per se. It's the legislature's rule. You're not allowed to drink alcohol. Do you understand? All right, I'm going to continue him because this is his first motion to revoke and it's for drinking alcohol. I'm not removing GPS. That's going to be a punishment.
Understood.
So he's going to have GPS for 60 more days. Do you understand?
Yes, ma'am.
Is there anything you do not understand?
No, ma'am.
And I want those sober support meetings, and you're going to do sober support meetings 60 and 60 days. Do you understand?
Yes, ma'am.
Is there anything you do not understand?
No, ma'am.
And for the last time, this is what I'm going to say. If there's an issue, let your probation officer know. If you feel as though they're not addressing it, you can walk into this courtroom. Do you understand?
I do. Yes, ma'am.
All right, thank you. All right, so it's going to be deny the motion, alternate amend conditions to include a TAP evaluation, out of custody, follow TAP recommendations. If TAP recommends inpatient, we'll start with outpatient treatment. There's going to be 60 sober meetings in 60 days and 60 days GPS. Yes.
I'm still waiting for an offer that I think that
Where's your client?
he is in the back.
Okay.
In custody. I have conferred with him about the case and
Okay.
that I don't like conferring with him out here with so many people. I think I've got all the discovery. He had a recent new case that I just received notification that was dismissed. I think that may impact the offer that I end up getting ultimately on the case. So I do ask for a reset.
All right, the court is finding there's sufficient evidence to find you guilty and the court is finding you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
All right, is there anything you wish to say on behalf of your client?
Your Honor, I would just like to make a brief record if I may.
Yes.
I just want for the record to state to the court that I had discussed this case at length with my client. We met while he was out of custody and went over all of the police report, 911 call, videos, etc. I negotiated the plea to waive 2 previous convictions that he had when he had gone to TDC previously. And while I believe that I've done a great job, I did explain very clearly to him that if he was not satisfied with the plea bargain offers, that he certainly could go to trial. he has, as the court's seen, agreed that he wants to take advantage of that plea bargain offer. And I would ask the court to go ahead and follow that and allow him to go ahead and serve the 1-year state jail. But I want to make very clear, and it always concerns me when somebody insinuates that I didn't do my best or didn't do a good job, because you know how hard we work. I know how hard I work. And I just want to make clear that I did everything that I could for this young man standing here before you. And I am asking you to please go ahead and follow that.
All right. And so with his prior trips to prison, then is that something, because I don't have that before me, is that something that would have made this enhanceable?
Correct.
And
To
with
a
the-
second-degree felony. Your
2 to
Honor.
20 years.
Correct.
Now, Mr. Ramirez, what I can tell you is I've read the police report. And honestly, from reading that, there's so much that could have went wrong. So the fact that you all have agreed to 1 year is to your benefit,
Yes, ma'am. I realize that.
because more is deserved.
I realize that.
And what I can tell you, if the state would have offered 15 years and went forward on the enhancements, I would have said, yeah, 15 years, that's about right. So you're lucky that your attorney was able to negotiate for you and only get 1 year for somebody who's been to prison on an offense that could be enhanced to a second degree.
Yes, ma'am, I know. I'm blessed. I mean, she's a wonderful attorney.
Well, then why all this hesitation and this, I don't know, attitude about, yeah, I think she's okay, or whatever you're saying?
I mean, no, it goes deeper than what it is. I'm saying, I mean, I have a 4A and a 12-year-old, and I've been going through emotional stuff personally, but I don't need no disrespect towards my attorney.
Well, the fact that you have a 4, 8, and 12-year-old and you're going to prison, and you've obviously been in and out of prison while you had those 4, 8, and 12-year-olds on the planet, that's your fault.
Yeah, I know that.
These are bad choices that you are making.
I already know that.
And so if you want to be in your children's life, that is not your attorney's fault. That's all on you
Yeah,
for
I
not
take
doing
full
what you're supposed to do.
responsibility. Yes, ma'am.
You're not stepping up to the plate and being a father they can look up to.
I know that.
And this whole thing, this whole police report where you're chasing somebody in a vehicle, guess what? When somebody doesn't want you anymore, they don't want you anymore. Relationship is over. Move on. And all of these relationships that
This
people
was
are
not
in,
somebody that he had- This was
I
a
know.
stranger.
I know, but all of these relationships that people are in with spouses, with girlfriends, with boyfriends, you have known your parents longer than you've known these people. These people come into your life for a year or 2 years and you act like you can't live without them. So here's the thing. You have children on the planet. If you're not going to be a good father to them, if you're going to be in and out of the prison, it's probably best that you cut them loose so that perhaps they can have a good start in life without you in it and bringing nonsense. I'm going to follow your agreement. I'm going to sentence you to 1 year in the state jail facility, give you credit for any time served. And I was tempted not to give you any credit, which I could do for that.
Did check, Judge, and he has calendar days, 191 days. And I'm so sorry to derail you, but
No.
it does, I take it personally when somebody acts like I didn't do my best, and I just. wanna
And the
make
court
sure
is
that
aware
I
of your
was-
work,
Thank you.
and the court appreciates your work.
I appreciate that.
And she also speaks Spanish. And Jason, I appreciate your work too. I don't want people to say I'm unfair.
I worked with Jason today, but I'll appreciate him later.
All right, it's there. I appreciate Jason Garahan. I appreciate Kathy Compton. I feel like Romper Room. I know I'm aging myself with Romper Room where she would look through the mirror. And Michael Villarreal, I appreciate you as well. Thank you. And everyone else who's in the room. All right, Mr. Ramirez, I'm showing you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, good luck to you. Do better, okay?
Thank you.
You're
Judge.
welcome. Thank you. Court is calling 2021, I'm sorry. Why do you think you're here?
For compliance hearing for coming out positive,
All right. And what else?
that should be it.
Well, let me just tell you the report I'm receiving on you. This is what the probation officer is saying to me about you. And how old are you?
20.
All right, you're 20. Since obtaining the probationer's case, when they say probationer, they're talking about you. He has shown zero to very minimal effort regarding his probation. The probationer has had issues reporting on time, reporting for field visits, testing positive for cocaine and meth, and enrolling or providing proof of employment for any remaining court-ordered programs. The probationer and I have had several discussions regarding his actions and how or what we can do to get back on track, really stressing the small actions, such as simply calling this probation officer within 24 hours after an attempted field visit or taking accountability for his action. The probationer appears to continue to struggle to grasp the severity of his circumstances and what he can do to grow and move forward with his life and the lessons he can learn on his probation path. That's the report that I have on you. The report tells me you are doing nothing, zero, nada. Why are you doing nothing on this probation in this court other than using drugs?
I have attended 2 out of the 4 classes, and we have had
No, they say you don't even call in.
probably when they come for a field visit.
Yeah, they say you're not doing the simplest of things. And what I can tell you is you've had 3 motions to revoke in this court. So, and I know that each time you came before me, I've told you that you're looking at up to 10 years in the prison. Deputy Laura, could you do me a favor? Could you place the handcuffs on him, please? Each time you come before me, I know I've told you you're looking at doing 10 years in prison. Obviously, your mother is not laying down the law with you at home. They say that you keep saying that you work with your mom, but you don't provide any proof. I can tell you right now, I'm not going to allow you to work with your mom because I don't know if your mom is actually having you work with her. So you are going to ISF. And the reason why I'm sending you to ISF is because you need an attitude adjustment. You understand? Now, if you don't want to sign to go to ISF, you don't have to sign for it. What will end up happening is a motion to revoke will be filed. So which would you prefer?
ISF, Your Honor.
All right. So he wants to go to ISF, and if you could put him in ISF cognitive.
Your Honor, so we, the recommendation was for local ISF.
Okay.
Patch, Your Honor.
All right. All right. So you're going to go to local ISF. This is the last time we're going to have this conversation with you following rules. Obviously, your mom is not laying down the law with you. So you're not going to be allowed to work with your mom. You're going to have to get a job with a different employer, because if you get a job with a different employer, that employer, if you don't report, they're not going to pay you. They're not going to call the court and say, oh yeah, he reported for work if you did not. Do you understand?
Yes, Your Honor.
All right. Do you want to go to prison?
No, Your Honor.
All right. If you want to go to prison, I will get an attorney appointed to you and you can go to prison and I'll send you to prison. How old are you?
20 years old.
All right, you're 20. You're going to have to start doing better. Do you have children?
No.
That's a good thing. Probation, this is serious. And I hope I'm getting your attention because we're not going to have a conversation again where you're not doing anything. You understand?
Yes, Your Honor.
Now, is there anything else you need to be successful on this probation?
No, it shouldn't be.
All right. Do not come back here again where you are not doing anything. You understand?
Yes, Your Honor.
I keep an open mind on everything, but we are not going to have any more compliance hearings with you. If I get a report and it appears that everything is in order, a motion to revoke is going to be filed. When a motion to revoke is filed, what ends up happening is a warrant is issued for your arrest, and you will be picked up wherever you may be. You could be at the grocery store in the middle of checking out or have already checked out. You know what's going to happen? Those groceries are going to be put to the side and they're going to take you to jail. If you are at home, they're going to pick you up and take you to jail. If you're in the middle of watching a movie and you're at the part where they're about to solve everything, guess what? If they pick you up during that time, you're going to miss what happens. Do you understand?
Yes, Your Honor.
In this court, probation is serious. In this court, communication is key. And probation officers know that I like for them to communicate with people. And that's why they put in here that they've had several discussions with you regarding your actions. Do you understand?
Yes, Your Honor.
All right, good luck to you.
Thank you.